Hello and welcome to this webcast conversation on creating an effective remote investigations process. My name is Emily Rickaby and I'm the Director of Shared Expertise and Strategic Projects at Ethisphere. We have a great panel assembled for this topic today. Before I introduce the panel, a few housekeeping items. All attendees are muted and in listen-only mode, but we do encourage your questions. Submit questions using the Q&A function of Zoom. We'll hold questions until the end of the webcast and get to as many as we can. When the webcast recording is ready, all registrants will get an email with the information to access the recording. We are pleased to have the following panelists with us today. Reagan Demas, partner with Baker McKenzie. Maria Zanfini, Vice President and Senior Managing Counsel for Investigations at MasterCard. Will Simmons, Head of Global Investigations and Associate Director of Ethics and Compliance for Lonza. Steve Spiegelhalter, Partner at EY and Area Leader for Forensic and Integrity Services in Washington, D.C. and Virginia. And our moderator will be Jerome Thomas, Partner with Baker McKenzie. And with that, I'll turn things over to Jerome.
Thank you, Emily, and good morning or good afternoon, depending on where you are. Today, we're going to discuss some of the legal implications and practical issues associated with conducting corporate internal investigations and corporate investigations under the current restrictions that we are all living under. Someone can maybe go to slide 5 quickly, that would be great. So as the calendar flipped from 2019 to 2020, most internal legal compliance departments and their external advisors were doing what they normally do around that time of year, finishing up year-end assessments, planning for the new year, conducting a post-mortem on enforcement trends from the prior year, and then fine-tuning, or in some cases, engaging in more significant changes to their compliance programs. However, less than 90 days later, we all find ourselves in a strange world where face-to-face contact is limited, in-person discussions have become virtually non-existent, and local and international travel have become incredibly restricted and in some places non-existent. This has created significant business disruptions, and corporate internal investigations are obviously impacted accordingly. However, even as we find ourselves in these new circumstances, companies still find themselves needing to continue with investigations for several reasons, including investigations that were ongoing, internal or government facing. There's obviously a risk of, and in fact, in these times, a heightened risk of improper conduct being engaged in at present. There's always a concern with waiting to commence an investigation will jeopardize the ability to retain evidence. And then there is obviously law enforcement expectations, as well as the ability to effectively remediate becomes diminished the longer that you wait to investigate. Having said all of that, what we'll be discussing today is how companies can go about conducting investigations in this current environment, recognizing obviously that things have changed. What I think you're going to be hearing and seeing is that a lot of what we're talking about, or going to be talking about here today, are items that in some form or fashion corporate internal legal departments and compliance departments and their external advisors have already dealt with. They have some exposure to them. However, we are now in a world where those issues and those risks and implications, for all intents and purposes, on steroids, because everyone else finds themselves similarly situated, having to conduct investigations remotely with little ability to engage in any face-to-face interaction. So there will be some tips shared by the internal and external pros on this webinar. And I guess with that, Will and Maria, over to you, maybe to kick off how from an internal or inside, corporate legal department standpoint, you all are looking at conducting investigations in this new environment.
Sure.
Sure.
This is Maria. I'm happy to start. You know, we are basically trying very hard to keep things BAU as much as possible. Of course, there are challenges. So what we're doing is, you know, doing a triage to look at sort of the triage the cases to, you know, the most important or critical cases from our point of view, and just trying to kind of figure out how we can stick to our BAU process as much as possible. So that would be because we are a lean team, and I know Will appreciates this because he also has a lean team. I think we were previously, you know, set up to utilize resources in the regions due to travel restrictions and so forth. So, you know, we're pretty much doing the same thing. We're trying to, you know, work with our counterparts in legal, corporate security, and compliance in the regions to do things like, you know, participate in interviews, help collect and gather, you know, documents or evidence, and just, you know, be a partner locally. Of course, in most places, everyone is under work from home restrictions, so it's kind of difficult to do any sort of in-person interviewing, but we're relying a lot more on technology, video conferencing, and the like.
And just to follow up on that, and Marie and I did discuss the leanness of our team. So in some cases, the remote investigations has been kind of the status quo and the normal. But I really wanted to highlight the point that Maria had indicated in terms of triaging your investigations as they come in. Clearly, there's some investigations that you need to jump on because things will go back to normal and you need to follow all the exact steps. But one of the things I found to be helpful is, as Maria had indicated, and everybody's aware now that of the work from home restrictions and things, the person that's raising that complaint, while it may come in and go onto the lower tier of the investigations that you need to action on, that is kind of their whole focus and their whole world right there. So that communication back to those reporters to say, you know, and be transparent and say, you know, thank you for contacting us. We will definitely look into this. There may be some delay. The longer you allow something to kind of fester, it becomes more and more overbearing on that individual, and they'll continue to reach out and continue to possibly think that there's, you know, some other actions going forward. So it's just really important to be transparent with your folks. And kind of further on that is just communication on the risk and the issues. And Jerome had indicated that in these kind of uncertain times, that's for a compliance person is the most disconcerting, because that's when there's an opportunity to, you know, to have this misconduct. So in respect to that is just make sure you're communicating with your teams, and that, you know, when you're reaching out to your business partners and your HR folks or whoever else, and letting them know that, hey, if there's something that needs to be actioned on, why it needs to be actioned. Because in a world right now where everything is being triaged and so many people are working various COVID-19 responses, you need to not lose the forefront if there's something that you need to work on, and explain the rationale behind that. Because otherwise, if you just kick it out remotely to somebody else, it may get buried down and you're going to kind of set yourself back.
And so then I guess if we could then move on to the next slide, Emily, on to slide, you know, perhaps even the next slide after that, so we can then talk about some of the practical implications. So after this, one more slide. So as Will and Marie discussed earlier on, what is oftentimes going to be key is triaging. You know, if you think about what a, you know, compliance program is under the DOJ guidance and the sentencing guidelines, at the very highest level, it is supposed to be risk-based. It's supposed to reflect the risks presented to a particular business organization. No one-size-fits-all approach, but it's supposed to be adaptive to sort of move where that risk is. You know, and as I was pondering that, you know, that old maxim under these current times, I thought that, were I, back in my days in the federal government as a enforcement lawyer, I would be looking at, I would be looking at a company's compliance program to see what they did and how they moved and how nimble were they in adapting to the new challenges presented by the business and the public health environment, but also internally was the program well designed? Did it adapt? Obviously, nothing is going to be perfect, but was it well functioning during this moment of crisis, or did it really maintain a status quo and not move to adapt what the emerging risk was? And I think that the concept of triaging is going to be critical here, as Will earlier mentioned. There are going to be any number of new and somewhat different risks that emerge. Cybersecurity, confidentiality and privacy. Also, if you were a public company, accounting and earnings announcements, as the SEC chief accountant announced yesterday. There is an expectation that companies are going to need to look very closely and make very difficult judgment calls on the proper accounting treatment when coming out with their annual or quarterly earnings announcements. And so as companies struggle with the new normal, they also need to be thinking about, what are the issues on the outside that either the government or that, intruders may be considering. For example, cybersecurity. Within the last week, some of you may have seen, 10x Genomics, announced that that it had been attacked by a ransomware. To disclose it in an 8K. Clearly, cybersecurity issues, not only from a pure outsider ransomware attack, but also, if you think about it, companies and their internal IT staff and their internal information security staff, oftentimes the things they look at in determining whether there's a particular cyber risk, including pings or hits from non-familiar or external IP addresses on a company's network. That's a fairly static number. I mean, it goes up and it goes down at certain times, but it's fairly static. In this environment, when an entire company's work staff is dialing in from new places every day, that internal IT staff, may be overwhelmed. Furthermore, employees are dialing in oftentimes from non-secure internet or other wireless connections. So ensuring that all protections are put in place to maximize or minimize the likelihood that an intruder is able to piggyback on top of an unsecure line into a company's IT environment. Those are challenges that are now on steroids, given that the entire workforce is working remotely. Privilege issues. Another issue to be thinking about very closely in light of the new remote workforce / lack of travel. Privilege is something that is inherently close. It's intended to be confidential, which is something that connotes a limited number of recipients and receiving information on a need-to-know basis. Well, obviously, in a remote workforce, email-driven communication world that we now find ourselves in, there are challenges that companies need to be aware of when conducting investigations, ensuring that that people who are being communicated with about investigations are being communicated with because they need to know, or they're essential to being a part of the solution, and not necessarily are a nice to have because they want to be helpful. Again, being vigilant with ensuring that communications, when reduced to writing, are absolutely essential, and limited in circulation is even more critical in these times. And then there are obviously issues around collecting information and evidence remotely, if it can be done at all. In many jurisdictions, people can't even leave their towns without prior authorization. So there are obviously, issues about how can a forensic consultant collect a laptop or a phone if it's two towns over. Here in the United States, for example, in most locations, travel is possible from one town to another. I know for a fact that it's not the case in other jurisdictions, South Africa being one of them. And so thinking about how you go about collecting evidence where there is a lockdown on travel, these are all issues that as we move into the next couple of weeks in conducting investigations, you'll want to plan out in advance rather than find yourself struggling with it in the middle of it. Will and Steve, maybe if we can go to the next slide, you could talk a little bit more about the evidence preservation and collection and the cybersecurity challenges.
Absolutely. So I think one of the first and foremost things with the cybersecurity aspects is, and I'm going to say this constantly through the webinar, is communications, and having that line of communications, not only with your IT resources, but making sure that they're communicating accurately out to the employee base. And a lot of that is exactly what Jerome was discussing, is people are now using their home networks. They may be using, box software or any of these other mechanisms to allow them to do their job. But in the same time, it's something that is not approved by the company. So it's really just having that communication out from the IT group, make sure there's alignment within that internally, and then reaching that out and explaining to the employees, hey, this is acceptable, this isn't acceptable, kind of a work sort of thing. And really quick, I want to touch on the privilege aspect. Is there's a lot of people whose work has been somewhat stagnated because, again, they're working remotely and they're not able to do the full amount of work they were doing. So in the case that these individuals are helping with an investigation or, are providing answers, they may be overly, putting too much in writing, essentially. So it's just making sure that people are aware of when they're communicating. It's exactly what Jerome had indicated, that it's a need to know, and it's the absolute amount that needs to be in there versus just people firing things off left and right. Because again, they're not doing it nefariously, but they want to be helpful. So it's just, again, something that people need to be aware of when you're reaching out to folks that maybe you have not worked with before in an investigation, is to let them know kind of some guidelines and standards of what is expected in terms of what the communication is. And really just kind of reiterate that, hey, if there's a question, let's jump on the phone prior to having some sort of document. Because again, when all this is normalized, those will all be records that are possibly available for anybody to view. So it's just something you need to have in the forefront, even more so now.
This is Steve. I can jump in if we can go to the next slide. Talk a little bit about, sorry, if we want to get to the electronic communication slide, the slide about gathering evidence. And I think the first thing I would do is just sort of step back. I joined EY after having worked in-house as an investigations counsel and a compliance officer. So I've confronted a lot of these issues. And before that, I spent 4 years in the Foreign Corrupt Practices Act unit at Department of Justice Fraud. And so, having been in both positions and now being at EY, I know that all of us on the phone sort of have to consider what our activities now will look like when they're judged a few months down the road or a few years down the road, whatever it might be. And so I think the first thing I would do is sort of put a regulatory frame on all this. And talk about how important it is. And I think Jerome made a good point about triaging. And then I think I would come in behind that and say, you really just have to document why you made the decisions you made. And then be able to put them back in the frame of kind of the current times that we're in. I saw a LinkedIn post this morning, or it might've been yesterday morning, that suggested that, for instance, the Foreign Corrupt Practices Act unit would probably take a bunch of time off. We wouldn't see many resolutions. We wouldn't see much activity, but I think it's actually just the opposite. And so those prosecutors are gonna also have, they're also gonna live in the times that we're in, and their jobs are gonna be different, just like the rest of us. They're not putting on a suit and going to work anymore. They're not sitting side by side by their coworkers. Instead, they're sort of digging in and digging into evidence and drafting papers and drafting documents and probably interacting directly with whistleblowers. And they're going to expect that all of us did our jobs just the same way we always would have been expected to do it. I think a couple of other things is they're going to expect a lot more whistleblower activity. If you think about why most whistleblowers or would-be whistleblowers don't whistleblow, it's because of the social context that they're in. And, working with coworkers worried about losing their jobs, Well, if we see reductions in force, if we see people who aren't around their coworkers on a regular basis, my expectation and my experience in the past is that DOJ will expect a lot more whistleblowers to come out of the woodwork, and they'll expect us to have have done our jobs as those complaints come up in the way we always have. Considerations around gathering evidence, I don't think that they're necessarily that much different, but the new situation really does require additional advanced planning. The first thing that all of us do, and I think this is the same whether we have COVID or we don't have COVID, is to evaluate who we're dealing with when a complaint comes in. And I think it's really important now, especially, to consider whether employees that you're going to have to deal with are likely to be friendlies or they're going to be adverse. And the second question is whether you can trust your local IT personnel. So as Maria said earlier, and Will, everyone's really used to working with their foreign personnel. But you have to consider whether those people are more likely to be close to your local CEO or your local manager, or whether they're likely to be close to you. If you could trust them, it makes things a lot easier to collect evidence, even remotely. I think the second thing that people need to do probably is just a little more groundwork, considering that the chance to confront an employee who might be engaged in wrongdoing is a little more limited now than it normally is. And so you have to consider whether you can do some background work remotely. For instance, at EY, we will sometimes take server data that won't give you the substance of a communication, but will sort of give you the lay of the land of the office that you're dealing with. You can do a social network analysis and really look at who's communicating with whom and weed through that to figure out where the power centers are and what employees are likely to sort of let the cat out of the bag if you go in and you talk to one of them, because you can judge a little bit which employees are closer to others. Your collections methodology will depend a lot on what you're grabbing, and also whether you think there's going to be a deletion analysis that'll become important in the future. And that really sort of dictates how you can approach the entire landscape if you're going to gather evidence. The lowest hanging fruit will continue to be O365 Mail and OneDrive. Obviously, you can still grab those remotely just the way you could before any of this happened. If you have a friendly employee, you can also use remote techniques to rely upon the employee's communication. So sometimes in this situation, we found that we're doing this more with clients these days. We'll have to remote into an employee's computer and work with that employee to identify key files and data. We can also, and you can do the same, courier a drive to your employee along with a license for the imaging software that they'll need. And you can work with your employees to get images of laptops or phones, even remotely. So, a lot of things you could have done in the past, but maybe you would have relied more on local IT to do that when they were sort of in a normal office setting. I think the trickiest situation, even before the global shutdown, was if you're dealing with a potentially adverse employee. Key decision point there is what you're going to communicate to the employee. Obviously, if you go overt, you risk deletion. If you go entirely covert, it's a more difficult gathering exercise for evidence. And so obviously you have to weigh which way you're going to go. If you're going to go overt, again, you can do some additional homework. You could remotely inventory the employee's computer before initiating communications. And so that first conversation with someone who is potentially a wrongdoer or the subject of allegations inside your company is a little bit different. You can use, In-Case Enterprise or other enterprise software to get onto their computers, take an inventory of what their files are. Again, you're not grabbing the communication, but you're grabbing more the names of the files and figuring out what's on that employee's computer. And then before you have that first conversation with them to let them know that they're the subject of an investigation, you can have a conversation that says, look, we've already inventoried your computer, so there's really no point in deleting a bunch of files. We're going to have to talk about all this. And I always found in-house and also as a prosecutor, obviously using the same soft touch that you use and just explaining to your employees that this is a normal investigative protocol that you're following. You haven't prejudged anything. It doesn't really alter those dynamics too significantly. If you decide to go entirely covert, obviously you can use, again, In-Case Enterprise and other programs like that to grab files off of an employee's computer as long as they're connected to the internet. The downside of that is obviously that if they disconnect, then the file share stops entirely, and you have to reset and start that all over the next time they get on to the computer. We've had this literally last for months when we were trying to do this, where someone would sign on for 4 hours at a time, and you just couldn't get the entire file. So think strategically about what you really need. Is there a PST file? Is there something else that you think you want to grab? And grabbing that high value stuff first, and sort of working in smaller bites. On grabbing ERP data, so grabbing your accounting data, which you have to do for investigations periodically, that's just that's a much easier exercise. You can sort of we on occasion, if we can't travel to a remote location, we'll just remote in, we'll do screen sharing, and it's pretty easy for us to judge if we got incomplete financial data on the back end anyway, using control totals, file counts, and then measuring everything against trial balances. So that one's just a lot easier. But coming back again to my prosecutor hat on, I think the key point here is to document what you did, to triage in the way that Jerome said, and then later on, months down the road when you're being judged, I think that you can explain to the prosecutor sort of the Hobson's choice, right? Your choice is you either do what you can do with the hand that you were dealt by the coronavirus and sort of all the limitations that we're under now, or you let wrongdoing continue in the company. And I think, I can't speak for every prosecutor. We've all encountered that one-off prosecutor that we thought wasn't as helpful as others. But I think in the main that message will really carry as long as you've documented why you did what you did.
Thanks, Steve. And so Reagan and Maria, you want to maybe talk a little bit about privilege considerations, obviously a thorny issue in the work from home environment.
Yeah, sure. We'll hit on privilege, confidentiality, and privacy, which are all related. Obviously, we could do a 1 hour, probably a 10-hour webinar on these issues alone, which we won't, so don't worry. But just to hit on some of the practical aspects of this, given the current situation, there are obviously a number of privilege regimes across countries. They're not all the same. Some of them differ substantially. The risk of privilege waiver has always been a consideration in investigations, but those risks are heightened now that you have more remote investigations taking place. So let's walk through a few practical, and some of these may seem obvious, but I want to make sure we're practical. So first, taking materials that may be privileged and potentially company computers or devices off-site to prepare for interviews. A lot of people do that on a normal basis. Now we're all sort of doing that because we don't really have a choice. And simple questions of like, do I have privileged materials? I don't have a shredder at home necessarily. Maybe I do, maybe I don't. How do I get rid of them? I'm a big recycler. Do I throw it in the recycle? Obviously not, right? So just thinking through the practicalities of materials that get taken home, which is a more common practice. Disclosure of information that may be privileged while interviewing. There was a question I saw that came through about telephone versus video interviews. Obviously, video interviews are far preferred to telephonic interviews for a number of reasons: credibility assessment, the ability to connect with the witness, understand the nature of responses. Sometimes it's not possible, but when you're sharing documents, you've got challenges with how you actually share those documents. Typically, you're sitting with the witness, you hand over a document, you take it back. The concern about that document escaping and either resulting in privilege waiver or confidentiality issues is minimized. Screen shares are a possibility. The challenge with that is people can take pictures of screens, they can grab screens. Sometimes the screen puts the doc up and you can't see the person, so your ability to, while you're showing the document, to assess credibility is minimized, so that's another consideration. There are ways to potentially have documents that are accessible on a protected site where only that individual can view only. Again, there are challenges and ways that you can, the individual can actually screenshot or take copies of those in certain circumstances. So that's a tough nut to crack, but one that you have to think through. Another issue is the challenge of controlling environments and attendees. And a lot of privilege regimes talk about the presence of unnecessary parties in conversations as potentially leading to waiver. Well, you got family members at home. I've run my kids out for now. That could change any second. But all of us are in environments, many at least, where the ability to know exactly who's necessary and not necessarily in the room is difficult. Even just yesterday, speaking with a client who was doing an interview remotely and heard kids in the background and a spouse and others. So thinking through how you do that and knowing who's present and requesting privacy is really, really important for all of these reasons. The use of personal emails, we've heard about this, but by witnesses to access work emails or materials, sending materials to their Gmail accounts. We all do it at times. You've got to be really careful with that, where you may not have access to work email or a printer on a home computer, and how does a witness download materials to prep, and are they sending things through channels that could be compromised from a privilege standpoint or a confidentiality standpoint. We've heard someone talk about witness email communications and making sure that those are protected. And if you're doing regular remote investigations, it's really important to just set protocols, communicate those to your team to ensure consistency on how your team is managing that. And Maria, I don't know if you wanted to comment any more on privilege. I think you had something to add there before we move on to confidentiality.
Sure. So just, as I said, we generally try and conduct our, we are conducting our internal investigations BAU regardless of COVID-19. And so one of the things that we do regularly is, like, when we reach out to other people for help or assistance in an investigation, we will have them sign a privilege investigation memo, which basically, kind of gives them sort of an Upjohn type warning and sort of helps maintain the privilege. So it basically tells them that they're being asked to assist counsel in an investigation. It identifies counsel, tells them that they need to communicate directly with counsel, explains to them how that they're taking direction from counsel, that they should not expand the scope of an investigation, that if they have any thoughts or ideas, that they should communicate those with counsel before taking any action and only take direction from counsel. It explains how to label all the documents and analysis they may do, privileged and confidential at the direction of counsel with the, matter number. And then talks about how to share those documents, either using a limited access share file and keeping those documents separate from their daily work. So, if you save things on a share drive, maybe you put these on a special drive on your hard drive that no one has access to, or your personal backup drive, or directly to a limited share file, just to sort of maintain the privilege and, ensure that, the investigation is actually being conducted by counsel and not by all of these other resources that you may need now in these, remote investigations.
Great. Thanks, Maria. So as we move to the next slide, slide 12, just hitting briefly on some practical considerations on confidentiality and privacy. We've hit on some of these, but that second bullet there, the thinking through the fact that some of the weakening or the greater risk on security and confidentiality in the context of current remote investigations. And by the way, we're talking about remote investigations on steroids. A lot of companies, I see a question came in about how many people conduct remote investigations. As Maria just said, a lot of companies will conduct remote investigations. It's not uncommon. We're talking about a scenario now where, number one, they're forced remote if you're going to do them, and number two, it's remote in a new kind of way. You're not in your office. You're in a different environment. And there's a risk here that information, to the obviously extent there's a privilege waiver, could be required to be disclosed either in litigation or, importantly, depending on the type of case, to a regulator. We've had a recent case where a regulator requested documents that were shown to a particular non-privileged party when the regulator became aware of that. And so it's a real risk in thinking through the protections, both from the privilege and confidentiality standpoint. Also, the fact that confidentiality can be broken, there aren't just privilege or legal consequences from that standpoint. There's also a risk that the allegations could become public. And that could increase the likelihood under voluntary disclosure regimes. For example, Foreign Corrupt Practices Act could change the calculus of the company when it comes to voluntary disclosure. So there are a lot of ramifications of the confidentiality concerns. On privacy, I think Steve hit on a lot of these, and that's a whole nother hour-long webinar, right? And there's a lot of regimes that impact this. But I think issues of sending devices outside of a jurisdiction like South Africa, as you mentioned, Jerome, to another jurisdiction for imaging, there are all sorts of issues that could be implicated from a privacy standpoint with respect to that. So the remote concept, especially when it comes to accessing data that's local that can't be accessed remotely, complicates what are already fairly rigorous data protection regimes, and critical to ensure you're obtaining local legal advice to monitor and to ensure that you're doing that appropriately. One final point, real-time monitoring can be a solution where you're not able to immediately access information that might be on a computer, or you're concerned about ongoing conduct. We've done that in a few circumstances. There obviously are fairly substantial privacy issues with that have to be overcome, but it can be done, and there are circumstances in the current environment where that might be the case. One final point I'll make on this relates to, we've been talking as if the entire world's on lockdown. It actually turns out that this has been a wave and will continue to be a wave. And there are a number of countries that are returning to quote unquote normal, the new normal, I suppose. China, for example, having had the wave hit early on, we're aware that our Chinese colleagues are conducting interviews. And so depending on where you are in China and certain circumstances, the new normal is returning. So as always, anytime you're doing remote investigations, you're typically going to want to rely on local counsel for key parts of that investigation. And so where there are countries that are not affected or are less affected, that can be done. So don't just presume that country X is under the same circumstances that the U.S. or wherever you're located might be under. And with that, I'll turn it back over to, I don't know if Maria or Steve, you guys want to comment?
Yeah, so I think we can probably, maybe we can move on to the remediation phase, but prior to doing that, which would be slide 14, prior to going on to slide 14, just one additional reminder on privacy considerations. There is an inclination to use current technology where available to potentially grab text messages, chat conversations, etc., remotely, thereby vitiating the need to do anything in person. Obviously, we in the investigations world love to leverage technology to the maximum extent possible. One thing I would caution, and again, this is not any different than what it was 3 weeks ago, but I would caution, in this new environment, prior to doing that, in particular, in the European jurisdictions subject to GDPR, but really in any jurisdiction, it would be to ensure to go back and look at not only your BYOD policies, but also your permissible use policies and any notifications that are provided to employees, just to ensure that the remote accessing of chats and text messages or other messages on that telephone or handheld device, that the grabbing of that remotely is consistent with those notices and with those policies. Again, you'd hate to stumble into a major GDPR issue in addition to this underlying substantive investigation. So again, leverage technology where possible, but when grabbing items remotely off of handheld devices, in particular in Europe, be mindful that you're doing so in compliance with your policies and also local law, in particular in Europe. I guess with that, Maria and Will, if you can talk about remedial considerations and how you go about that in the remote workplace world.
Sure. So I think, with discipline and remediation aspects, that hasn't changed. If there is the finding of misconduct, you need to stop the bleeding immediately. Now, how you do that may be a little bit different, obviously, because we're remote. And so there's some considerations that you might want to put in there in terms of, is this, computer-based? Does this person have access to various systems that the company has or something else? Can you, remotely terminate that access? And by working with your IT group to either disable, passwords or basically lock them out of the system. But again, I think it's a matter of communication as well, because it's going to depend on the role of the individual, what they're doing for the company, and making sure that management is aware as well as for the disciplinary actions. It can't be done in a vacuum because there could be other things that are being worked that possibly you're not aware of in support of either operations or business conduct respective to COVID-19. But having that communication and making sure that you're aware, it just has to be something that, again, you stop the bleeding, but then you're going to have to figure out the best way to pursue the next steps. So is that remote access, shutting down and wiping the computer? Is that getting on a phone call and telling them to knock it off because maybe it's against a policy or procedure that can be dealt with after things are quote unquote back to normal, but doesn't have any impact right now. So it really depends on the level of the misconduct and the impact of that operations that that person is doing. So Maria, any thoughts on that?
Yeah, so I mean, I again, I feel like, you know, it's, this is something that we do on a regular basis anyway. And so we always involve, you know, employee relations or HR or whatever the group is, you know, corporate security, you know, when, you know, for example, we may be interviewing subjects of an investigation, we would always let corporate security know and HR know. In the event that after the investigation is completed, we would want to turn off access to their laptop, or, you know, have considerations as to whether we would want to put the person on administrative leave pending, you know, the completion of the investigation. So, you know, we try, I think it's really important to have those communications, you know, despite, you know, even when there isn't a pandemic going on, be prepared for the potential outcomes when you're interviewing subjects. And then in terms of, you know, disciplinary actions, those are normally handled by our employee relations group, along with, you know, the region council and the line manager. So, you know, that would always be, in many cases, you know, when it's a remote location, those would always be, you know, either be Skype or video Skype, however we do it. So, you know, that pretty much has been the same. The other, you know, the other thing I wanted to mention, just to comment a little bit on what Will and Steve said, is the other thing that I think is also a best practice is whenever you're grabbing anything remotely, always double check with your, you know, privacy folks, no matter what location, even, you know, even if it's not just the EU, we always try and do that. We have a system in place where they respond pretty quickly. There's a short form you fill out as to, you know, what you want to access, why you want to access it. And you can say internal you know, something very high level, internal investigation in connection with an allegation of XYZ thing. And so you always have those things preserved and ready. So, you know, a lot of the things that we're talking about now are just really best practices on, you know, how you would handle an investigation under any circumstances, and the communication with the various, you know, teams that you need, you know, privacy, corporate security, HR, or employee relations, whatever you call them. It's always very, very important.
No, that's absolutely great. And just kind of two further points I wanted to follow up on Maria's talking regarding communication is, you know, I had mentioned this before, but having communication with both reporters, anybody else that's associated with an investigation is very key, as everybody is now working remotely. So there may not be that opportunity in the near future to be able to stop by the office and let them know that this, you know, this investigation was conducted, and at whatever level you can is to let them know that the findings are and everything. So having that remotely, and either it's via email or phone, or if based on your hotline system, if you can reach out to the reporters, just letting them know that these things are being addressed constantly is something that just, it benefits the trust and the feeling of, you know, the company's taking care of you. But then if people are aware that, you know, hey, business is still going on. And with the business still going on too, I think as the world has been thrust into this pandemic, we are learning a lot of ways of, you know, different ways to work, you know, Zoom, everything else, all these different technologies that we're using. So from an enterprise risk management, compliance professionals may be exposed to things that they never thought was a risk, and you never thought that you'd have an investigation of this manner. So I think it's very important to encompass all of these, collect everything, so that when things are quote unquote back to normal again, that you can be prepared, because this will introduce new ways of potential misconduct that previously we didn't think or consider just because it was business as normal.
Thank you, Will and Maria. So, you know, maybe with Reagan, if we can move on and talk about what we are seeing, hearing, and experiencing from the government in the current environment.
Yeah, thanks, Jerome. I mean, I think this is changing literally on a day-by-day basis, and obviously by jurisdiction, as I mentioned, as this wave flows. Our general experience is that U.S. law enforcement and regulatory investigations are still active, if not potentially slowed or focused on items of priority. Other jurisdictions have slowed. Some have come to a screeching halt as with firm lockdowns, but that's sort of on a case-by-case basis. Let me make a couple of points on just the general scenario where you're involved in government investigations that are at least before regulators. On internal reporting, so it's really important, obviously, in those cases to continue to keep boards and audit committees and other key stakeholders up to date through remote channels, which most companies have set anyway, with boards often located outside of one jurisdiction and one location. Also, it's important to keep regulators up to date on any plans you have. So I think Steve, and based on his experience in the fraud section, said this really well, right? I mean, you want to be able to defend what you do ultimately to a regulator, but in many cases you can tee it up in advance. And if there are particular protocol adjustments you plan to make, you can tee that up and let them know. It gives you, implicit buy-in where you let them know, and sort of without pushback, you sort of got an implicit buy-in on that front. It allows you to sort of maintain and in some ways control expectations of regulators in terms of timing and process. We have an ongoing matter where the Department of Justice was interested in conducting interviews, and we alerted them to the developing company policy and guidance and travel restrictions, et cetera, as this developed. And that regular communication really helped set expectations on all sides, and quite frankly allowed us to get a sense of the government's expectations and their plans, which is always nice to have as much insight as you can into how the regulator's approaching it. So that communication's really important. Obviously, in all of this, it's really important and seems obvious, but should state the obvious, not to put your employees or representatives in any sort of danger by asking them to do something that is either against local guidelines or regulations in terms of stay-at-home or lockdown procedures. And I'm aware of one situation where a due diligence provider managed to get a on-site report put together in a jurisdiction under complete lockdown, and scratching our head with the client about how that may have happened. So I think the bottom line is just make sure nothing is worth, obviously, the health of your own people or the people working with you. And then just a final point on this, we've talked about a lot. There are a lot of things that can be delayed, that can be sort of slowed, pending, because we all do believe this will be temporary, at least the significant situation we're currently in. That includes potentially interviews or data review. You can defend that to regulators, a slowdown or a delay, but there are two things that are very hard to defend ultimately. And one is stopping ongoing improper conduct if it's known. You're going to have a hard time before a regulator saying, well, we couldn't stop it making that improper payment or committing that fraud because of COVID-19. And the other one is preservation of evidence. It's really important to find a way, even if it's creative, to preserve evidence, because spoliation of evidence is not looked upon particularly fondly by regulators, to say the least. I don't know, Jerome and Steve, you guys want to chime in on this?
Yeah, Reagan, I will quickly. What I've experienced, because I do spend a lot of my time dealing with the government on federal government investigations representing both companies and individuals. What I've noticed is that the government lawyers are using this time in certain cases. Obviously, it's case to case. To essentially take stock of where their evidence is based on what's been produced to date, and are inquiring on status of productions, inquiring on when productions will be completed, inquiring on when certain written submissions that don't necessarily require face-to-face interaction will be submitted. Many of these federal prosecutors have rigorous court schedules, which now have largely been slow to a halt. So they have a lot more time to, I think, take stock of their investigations, as do other government enforcement lawyers, because they just have more time to think about the investigation and not necessarily the prosecution aspect. Secondly, I also think that that the government, when they want to continue with a particular request, will be looking for technology to help leverage that request. For example, we're working on a case where a client's officers were requested to sit down under subpoena testimony under oath on the record. Obviously, given all of what we're experiencing now, that is not going to happen. The government quickly responded by saying, "Well, let's do this. Let's do a telephone interview. Obviously, subject to all the trappings of the false statements of 18 U.S.C. 1001. Let's do an interview, see what we have, and then we'll decide whether we need to go forward with testimony or not." Obviously, that's a unique government investigation issue that doesn't necessarily pop up in internals, but it's certainly something for those who are before the government to be thinking about what the government is thinking and what they may be coming back to you with as possible alternatives. Steve, I don't know if you have any further thoughts.
I think you guys have both nailed down, the key points in this area. I would say Reagan's point about talking to the government about how you're going to proceed is a really good one. If you're in a surfaced investigation, you're already dealing with the prosecutor. That goes a long way, even not in this circumstance, to go and talk to the prosecutor about how you think you're going to proceed, obviously within reason. Interesting, I think Jerome and maybe Reagan, you were talking about how federal prosecutors, a lot of them have rigorous court schedules. The DOJ fraud people, generally, they're not in trial as much as someone sitting in the Southern District or whatever it might be. And so they're sort of used to this schedule. I don't think there's going to be any major change. DOJ prosecutors at Maine, at least, don't have to go to the grand jury very often. And so really all of their investigative tools that they would normally have are still at their fingertips. They can still do everything that they've already done. In the past few years, have gotten a little bit better as well about using technology, just because the government's been under restriction for a long time, not because of the virus, but because of budgets. So I had instances when I was at Maine where I wanted to interview witnesses in a matter who were sitting in Australia, and I use WebEx just like you might use WebEx sitting in-house, or we might use it at a law firm or a consulting firm. And so my suspicion is, just the same way that we've all taken a gut punch and we're stepping back and figuring out how we're going to proceed, they're doing the same thing. And I think in matters that are already going, we have seen the normal amount of traffic. I think that Jerome is right, Reagan was right, that prosecutors are using this time to advance cases that maybe have been dormant, and ones that are moving along, I think they're going to continue to move along. But I think that, they'll probably come back in the near term and think about ways like we've been discussing to gather evidence. And that could be as simple as having executives at your company appear on WebEx for an interview.
Thanks, Steve. If we could maybe go to slide 17, wrap up here and leave some time for questions, talk about some of the practical considerations here. Practical tips. I think we've touched a lot of them. I don't know if any of the panelists have any particular thing that we've discussed in the last 55 minutes or so that they want to touch on, but in particular. If so, please obviously jump in. But the key obviously is, have a documented common sense triaging process. And ensure that you're doing what you can to stop ongoing conduct, right? When this all comes out of the wash, what you want to be able to do is to the government is stay with the straight face. Look, we looked at the risk, how it was evolving. We made a good faith estimate on what made sense to spend our limited resources on, and we dedicated those resources to investigating those issues, and then we dealt with the less serious issues as the more serious issues were resolved. I think in a nutshell, doing that and also providing clear instructions to your investigations team on what they should and should not be doing, who they should be speaking with, how they should be speaking with them, what should be oral, what should be in writing. all of these are things that are kind of investigation guidebook, 101, but in these times it makes sense. So I think revisit all of these things. I don't know if the panel has any other thoughts before we jump into questions.
Okay,
Let's hit the questions,
hearing
Rob.
nobody else. Yeah,
Yeah.
let's do it. We have a couple questions here specifically. I think, Steve, these would be great for you, and they're somewhat related. So one of them is, how would you go about cases that require disk imaging and gathering of data at remote locations? And related is, what would be a good idea? How do you instruct employees to hand over the devices for forensics to collect them and process if you can't do so in their presence?
Those are great questions. So look, I think the first thing that we would prefer to do if we can't be there in person is to remote into the computer. That might involve just using Skype, using WebEx, whatever it might be, and taking control of the computer. And then we use software that allows us to do a normal imaging process. Like I said, we can ship drives and licenses to employees and walk them through as well, or obviously take control of their computer and create those images in a way that would be defensible later. And you can really get to essentially a full forensic image that way. So if you're worried about things like chats, or ephemeral messaging and whatever signature that might leave, for instance, on a cell phone, you can still grab that stuff. The other possibility is to courier. I've been working with clients recently in remote locations where we'll just have someone courier in the machine. And the third thing is, we are in some locations just taking account of how the virus is operating and whether people are comfortable handing off machines. We have sent out techs with surgical gloves and masks and accomplished a handoff that way. So I think there are a lot of different ways to go about it. I saw a question also come in about what technology we use exactly. If we're grabbing chats, we might use Cellebrite remotely. If we're grabbing Signal, XRYP Photon is something we might use. And if we're just making a normal image, FTK Imager is one of the technologies that we'll use. So, to the extent that you have IT personnel who want to try those techniques on their own, those are certainly available. And obviously, lots of different consultants would be available to help you out if you needed to try that as well.
Great, thanks, Steve. One question here, and we'll have Reagan take this one. In terms of going about the interviews themselves, do you advise or recommend advising the interviewee that you are not recording and then somehow trying to confirm that they are also not recording?
Yeah, so I see a number of questions about recording interviews. So this is a challenging topic because across jurisdictions and cultures, there are different practices and there are people that swear by recording interviews. I can tell you that it's fraught with challenges and issues, and let me go through a few of them. I mean, the first is from a legal standpoint, and not just state to state in the U.S., but country to country, there are disparate requirements on consent, many of which require consent of both parties, in some case written or affirmative consent, and not just applied. So you've got the legal challenge of that. Separate and apart from that, there are substantial privilege considerations and confidentiality considerations. You've got a recording. If you're doing it and the other side is almost certainly going to want a copy and may even have a right to a copy depending on the jurisdiction, there are privilege implications. Even obviously the recording itself is not privileged. Your written work product, if you're a lawyer, could be privileged, but it really depends on the nature of the product and how it's written. And when you have a recording, an argument could be made that it's built from a recording and it's more akin to a transcript. So there are privilege issues as well with that. And then you've got the additional challenge of moving recordings across borders, right? So maybe in country X, you get the consents or you feel comfortable recording and you have a reason you really want to do it, but then you need to move it from X to country Y because country Y is where the lawyers are that need to, dissect it and understand what happened. You now have a whole nother jurisdiction set of laws that need to be implicated and considered. So in general, recording interviews is not something that we do. And typically we suggest that interviews not be recorded. I understand there are people that have different views on that, and a lot of that depends on the specific jurisdictions and in some cases the specific nature of the case that you're involved in and the nature of the interviews.
Great, and maybe we'll do just one more here. There seems to be some questions about either specific classes of cases or types of cases, but generally, are there certain interviews that you would say cannot be done remotely, or really is there a way to do almost any interview remotely?
So I think in that regards, you know, it obviously an in-person interview is going to be the most beneficial. So there has to be a weighing on the risk of what the company sees the issue is, and how big of a problem or what level of misconduct it is to determine, you know, is this something that we would be sufficient enough to conduct, you know, remotely, and we can deal with the pieces afterwards, or is this a quote unquote bet the company risk that we absolutely have to have it in an in-person interview? So I don't think there's a necessary right answer, or we can go through and say, here's cases X, Y, and Z that would have to be in person, or cases A, B, and C that can be remotely. That would wholly depend on the misconduct and the risk tolerance of the company. But welcome conversation from the other panelists on what their thoughts are.
Yeah, this is Maria. I definitely agree that, you know, in some cases, it's important enough and you just have to do it because the current situation is fluid, and can't really put a timetable on when, you know, conditions are going to go back to the old normal. So I think you really have to look at, you know, what the allegations are, what the conduct is, how critical it is, and, you know, the importance of basically, you know, stopping conduct that is inappropriate or improper. So I agree with Will, there's not really a set, you know, classification of when it's okay to do it remotely. I think, you know, if it's important enough, you have to just kind of make do with what you have, play the cards that are in your hand, and go ahead and do it remotely. And, you know, sometimes it's helpful to maybe, you know, turn on insider threat monitoring or some kind of computer monitoring so you can kind of see after the interviews if people are deleting anything or what they're doing. I mean, you really have to, in these days, leverage technology as much as you possibly can, and hope that that sort of fills the gap a little bit for the fact that you cannot be face-to-face or have someone physically present at, you know, some of these interviews.
Well, thank you. Thank you. I'm noting that we're a few minutes past the top of the hour. I want to take the opportunity to thank all of our panelists, but also you know, to thank everyone who joined the webinar today. This was a great event, very topical. We're happy you took the time out of your day to join us. We have a list of the questions that were received, and we'll going to be taking a look at them in greater detail as you know, as the afternoon and tomorrow progresses. And certainly we thank everyone for their active input and questions, and hope you got a lot out of it. And I guess with that, I'll hand it back over to the folks at Ethisphere.
Right. Thanks again, everyone, especially our panelists and Jerome as moderator. Excellent job, certainly a timely topic, and we appreciate everyone's attention and participation. As Jerome said, we will be following up with those questions that we weren't able to get to during the live broadcast, and you will receive an email as soon as the recording is available. We'll get that off to you along with the PowerPoint slides. So thanks everyone for joining us again, and we hope you have a great rest of your day.